Hello, I'm Justin M. Kennedy, an attorney with Little Kennedy and Associates, a California estate planning and elder care law firm. Today I'm going to discuss the new book I wrote, Yes, You Need an Estate Plan. As an estate plan attorney, I meet with many people who understand the benefits that a living trust can provide. Based upon the title of the book, you may be thinking that everyone needs a living trust, but that is not true. Let's look to an example of Ben, an 18-year-old leaving for his first year of college. In this example, Ben has almost no assets. He does not need a living trust. What if Ben fell down a flight of stairs at the college? Could you imagine Ben's parent being unable to find out how Ben is doing? This is where the HIPAA release would authorize Ben's selected loved ones to find out how he is doing and what room he is in. In the healthcare power of attorney, also known as the Advanced Healthcare Directive, Ben would authorize agents to make medical decisions for him if he was unable to make medical decisions for himself, such as if the fall left him unconscious. In this example, Ben would need an estate plan consisting of a healthcare power of attorney and HIPAA release. Fast forward 5 years, and Ben has graduated from college and is working at a tech company where he has received stock options and other benefits that need to be exercised by certain dates. What if Ben is in a snowboarding accident that leaves him mentally incapacitated before he was able to exercise those stock options and other benefits? This could result in Ben losing hundreds of thousands of dollars of benefits simply because he was unable to exercise the options himself. This is where a financial or property power of attorney, also known as a durable power of attorney, could step in and authorize Ben's trusted loved ones to exercise the options on Ben's behalf during that period of incapacity. This would result in a massive benefit to Ben. In this continued example, because Ben is starting to accumulate assets, he would need an estate plan that also contains a financial or property power of attorney. Now let's imagine that Ben married Lily, and in another 5 years, they have 3 children. What if Ben and Lily get a babysitter so the two of them can have a nice romantic night, and on that date night, they are in a car accident that kills them both? Ben's relatives and Lily's relatives could end up in court while a judge who did not know Ben, did not know Lily, then decides who will become the legal guardian of their 3 minor children. Rather than the family coming together during this difficult time, the families would hire attorneys and argue in court about why their side is the best and why the other side would not be as good. To avoid this, Ben and Lily could have each signed a will that listed who they trusted to serve as the legal guardian for their minor children. In this continued example, because Ben and Lily have minor children, they would need an estate plan that also contains a will. What if Ben and Lily bought a $1 million house together? Let's assume they paid a down payment of $200,000 and had a mortgage for the remaining $800,000. We can agree that if they sold the house, the net equity in the house would only be the $200,000. But if they died and this house had to pass through the court death probate process, then this estate, the probate fees, would be based upon the full $1 million fair market value as valued by the court's probate referee. The court does not look to the net equity in the house. Instead, the court only looks to the gross value. In California, that $1 million house would result in $46,000 of statutory probate fees. In this example, because Ben and Lily own a house in California, I would recommend that they have a living trust estate plan. With the house properly funded into the living trust, The House would avoid the court death probate and the expensive statutory probate fees. For even more what if protections, Ben and Lily would want to create a comprehensive living trust estate plan that would include the healthcare power of attorney and HIPAA releases, the financial power of attorney, financial or property power of attorney, the wills for a married couple, a community property agreement, and a living trust that has been specifically designed for Ben and Lily that helps them to accomplish their goals of protecting their children's inheritance from divorce or creditors, to allow them to delay the child's access to their inheritance until the child is mature enough to manage their inheritance, or to allow for the inheritance to be held in a special needs trust to supplement any government benefits the child may otherwise be eligible to receive. While the comprehensive living trust estate plan offers many protections for their children, it also provides benefits to Ben and Lily directly, such as if they were concerned about how to pay for long-term care, or if either was concerned about the survivor of them remarrying. At various stages of life, those over 18 may need different levels of estate planning documents. Maybe they only need an estate plan that contains the healthcare power of attorney. Maybe they need the comprehensive living trust estate plan, or something in between. When I am asked by someone over the age of 18 if they need an estate plan, my answer is yes, you need an estate plan. We just need to determine what documents would be needed in that estate plan. If you would like to learn more about the Comprehensive Living Trust Estate Plan, then I invite you to attend our free Living Trust seminar. You may find out about our upcoming presentation dates on our website, attorneyoffice.com. That's ATTORNEYOFFICE.com. If you would like to order a copy of my book, Yes, You Need an Estate Plan, you may do so on our website, attorneyoffice.com/book. Thank you.